Hello everyone. Today in this video we are going to discuss the judicial interventions on right to health as a fundamental right. Okay. So the very important landmark judgment that we are going to discuss in this video is Parmanand Katara versus Union of India. Now see, this is a landmark judgment which we have studied and we have come across many a times uh, you know in the Constitution of India. So if we talk about this case, this is 1989 Supreme Court judgment. Okay, and in this case, what happened? There was a person who was knocked down by a speeding car. Right, so he was lying down on the road, and some people, who were passing from that road, they picked him up and took him to the nearest hospital. Now, what happens? The doctors, in that hospital, they refuse to admit this injured person and, ask these people who have taken him to the hospital to shift him and to, admit him in a different hospital. And that hospital was, located somewhere around 20 kilometers away. So, basically this victim, this injured person, what happened while he was traveling from this hospital to another hospital, meanwhile he lost his life. Okay, he succumbed to his injuries and he could not reach the hospital. And in the first hospital the doctors refused to attend him, because they said that it is a medico legal case. All right. So in this case, what happened? A writ petition was filed under Article 32 of the Constitution of India, and the Supreme Court in this case observed that whenever an accident takes place, right, and the victims, they are taken to the hospital or to any medical practitioner, right, the first duty of the hospital and medical practitioners is to provide that victim immediate emergency medical treatment, right. They cannot refuse to give admission to the victim or to the injured person on the basis that it is a case of medico legal case, right, and that the victim should go to a government hospital or elsewhere. So in this case, the Supreme Court, it emphasized that, it is the need, it is obligatory on the hospitals and medical practitioners to provide medical emergency to the victims, right? Also, what happens, we all have seen that at times, what happens, these hospitals, they refuse to admit the person, because they are not able to pay them immediately, or they are not covered under any medical reimbursement scheme, right. uh, they have no insurance. So there is indifference of attitude towards the victims of accidents, right, when we go to the hospitals, right. And also we have seen that in India and many other countries, the situation is not only limited to the victims of accident cases. Other, we will see that even women, right, those women under labor and they're about to deliver, they're also refused admission in various hospitals, right. If we look and if we talk about the foreign jurisdictions, let's take the example of United States of America. So there is a statute, Emergency Treatment and Labor Act, right. It was enacted in 1986 and it was merged into Consolidated Omnibus Budget Reconciliation Act 1985. In short, we call it COBRA. Right. So this act is also known as Patient Anti-Dumping Act. This act actually imposed, on hospitals mandatory duty, right? And they're bound to give medical treatment to patients who are in emergency medical condition and women who are under labor, right. And if they fail to give admission to such people, then they will be punished under criminal law, right. So in USA this is a law. Now see, the Supreme Court has said in this case of Permanent Katara versus Union of India, it has referred the statute of USA and other case, other laws. So you know the Supreme Court observed that hospitals and medical practitioners, they will initially screen the person, right, to decide if there is medical emergency treatment or not. And if they do not require any immediate medical treatment, then especially, they need to be stabilized and they must be given treatment. But after that screening, they can be shifted to some other emergency medical hospitals, right? But the safeguards have to be taken, right, while transferring that victim to some other hospital. First, you have to give him proper, basic treatment. Only then you can transfer that victim to another hospital. Now, see, if it is a case of emergency, okay, then the hospitals and the medical practitioners, they are bound to provide basic medical needs to that person. They are bound to stabilize that person, right? In the previous video, we have seen the director principles of state policy, wherein we had seen that the state is also bound to provide adequate medical facilities for the people who are in essential need, right? So, in this case of Parmanand Katara versus Union of India, the Supreme Court has given certain directions to the state, to the hospitals, right? And they are bound to follow them, right? You cannot leave a person lying injured. Why? Because he is not able to pay. He does not have any medical insurance. The first important, in fact, the ethical duty of doctors also say that they are bound to provide immediate treatment, the first aid to the victims of accident cases, right? Now, see, moving ahead, there is also a landmark judgment, Paschim Banga Khet Mazdoor Samity versus State of West Bengal. All right. Now, in this case, what happened? There was a person, right? Hakim Sheikh, right? So he was a member of Paschim Banga Khet Mazdoor Samiti, and he's also a petitioner in this case. So he filed a petition under Article 32 of the Constitution. Now, what happens? This was an organization of agricultural laborers, and this person, he fell off a train at a station in West Bengal, and he suffered multiple head injuries and brain hemorrhage. So he was taken to a primary health center, and in this primary health center, what happened? Facilities for treatment were not available at that point of time. So the charge of the center, he referred this person to some other hospital for better treatment. Right. So this person Hakim Sheikh, he was taken to some nearby hospital. Right. And what happened that the emergency medical officer, he examined him, and after examining him, he recommended immediate admission for further treatment. But Hakim Sheikh, he could not be admitted to that hospital because there was no vacant bed available in the emergency ward, right? And he was further shifted to some other hospital, and there also he was not admitted on the ground of no bed available at that point of time. So he was shifted to another hospital, right? So now what happened, in that hospital there was no ENT emergency or neuro emergency department, right? Now again he could not be admitted. So in one of the hospital it was found that there was a hemorrhage condition and that was an emergency. So uh, but since this is a case of neurosurgery and no facility is available, so he should be shifted to some other hospital. Now see, again and again this person is being shifted to one hospital to another hospital, right? And that too in the case of emergency. See, he had multiple head injuries, severe brain hemorrhage, right? Now what happened, this person was hospitalized in one of the private hospitals, all right? And there, you know the medical expenses that he was immediately asked to pay amounted to rupees 17,000, right? Now this person, he could not pay immediately this amount of rupees 17,000, right? In this case, what happened? The Supreme Court, right? The Supreme Court said that the state is a welfare state, and it is the duty of the state to provide in the hospitals proper medical facilities, right? To give medical aids and assistance to the needy whenever it is required, right? In if you remember the case of Vincent versus Union of India, right? We have heard many a times in the Constitution of India. In that case, it was also observed by the Supreme Court that healthy body is the foundation of all human activities, right? And it is a duty of hospitals, duty of state to provide provide adequate medical facilities in the hospital so that a person who is in need in emergency situations can be given proper treatment at that time, right? He should not be shifted from one hospital to another hospital due to lack of bed, due to lack of neurosurgeons, due to lack of bed facilities, medical tools and instruments that are required for surgery. So all these things should be adequately available in the hospitals, right? In fact, we have seen Indian Medical Council Act, right? We have Geneva Declaration of 1948. So obviously the hospitals should be, they should be super fast also, and whenever they see a person who is in adequate requirement of these facilities, they should have all these proper tools and instruments available with them to provide assistance to that victim who is injured, right? They cannot say that since this is a medical legal case, or this is a case of accident, so we will not give admission to that person. First aid should be immediately provided, right? Now see, in another case of Pravat Kumar Mukherjee versus Ruby General Hospital and other. See, in this case also, the National Consumer Disputes Redressal Commission, right? It declared that hospital is under a duty. It is bound to accept accident victims and patients, right? If they are in a critical condition, and they cannot refuse treatment just on the ground that the victim is not able to pay the fee, or is not able, or is not in the position to meet the expenses, right? Or there is no close relation of the victim available at that moment who can give consent for the medical treatment, right? So in Pravat Kumar Mukherjee versus Ruby General Hospital, in this case there was a lady, right? There was a old student, 20-year-old student, who was injured and admitted in a hospital, right? He was hit by a motorcycle. So he was taken to the hospital, Ruby General Hospital. He was conscious when that victim reached the hospital. And that victim showed the doctors his Mediclaim policy, and the insured sum was of rupees 65,000. Right? And he assured that the medical bills will be cleared, and he requested the treatment should be given immediately to him. So the doctors, they started giving him emergency treatment, but soon they demanded, rupees 15,000 from the persons who brought this victim to the hospital. So those persons, they paid him rupees 2,000, and they informed the parents of the victim that they should pay the balance. However, what happened? This rupees 15,000 could not be arranged, and the hospital, they discontinued the treatment, and the victim died. Right. So the case was taken to the National Consumer Commission, and then they imposed damage of rupees 10 lakh on the hospital. And then they observed, right, that the doctors, they should not demand fees, first. First, they should, agree to treat the patient, right? Their prime duty is to preserve the life of a human being, right? That is of paramount importance, right? And this is also in consonance with the code of medical ethics, right? Recovery of fees can wait, but treatment cannot be denied, right? So it is a responsibility of those persons who are in charge of the health to preserve life of the community, right? Duty to take care. All right. Now see, this is a very latest case of 2022, that is Isha versus Union of India, and this girl is a minor. Okay, so what happens? This girl's father, he is a daily wage earner, right? And he has no source of income since lockdown. So what happens? Right? This girl needs immediate treatment, right? So he has approached the High Court for providing free cost of treatment. Now this child is suffering from a very rare disease, that is Gaucher disease, right? It is a genetic disorder where uh, fat laden Gaucher cells build up in the areas of spleen, liver and bone marrow, and they require immediate urgent treatment, right? Enzyme replacement therapy. So if not treated every week, this disease can prove to be very fatal. The enzyme replacement therapy almost costs, it cost almost 50 lakh rupees. So this father of the child is incapable of bearing this cost. So, you know, in this case, a petition was filed, and Justice Kameshwar Rao, right? he has granted immediate and interim relief to the party and directed aims to provide, free of cost treatment immediately, right? Because a child is supposed to receive, weekly treatment of enzyme replacement therapy, right? So, uh, you know, uh, now see, all right, so basically in this case, Justice Kameshwar Rao, while granting interim relief to the party, he said that, denial of free cost of treatment to the petitioner, it will amount to violation of the fundamental right? Guaranteed by the Articles 21, 14, 41, 43, Article 39, Clause Z of the Constitution of India, right? Now see, there is another case, Chinmay Mishra versus Public Health and Family Welfare Department and others. So this is, this was filed in the High Court of Madhya Pradesh. See, this is a public interest litigation which was filed to basically strengthen health services in rural and tribal areas of Madhya Pradesh. So what happens in this petition? The petitioner, he has provided a data to the High Court, right? Data provided by the National Family Health Survey 2019 to 21. And this petitioner has submitted that, uh, the health related to women, children is alarming in the state of Madhya Pradesh, right? And he has revealed that, the state has a worst rate of infant mortality ratio in India, right? The state has poor performance in maternal mortality ratio, etc., etc., right? So basically, he has pointed out about the sorry state of, medical infrastructure and manpower in the rural and tribal areas of the state of Madhya Pradesh. So he has said that, uh, the petitioner has said that in various judgments, the courts have declared, right? He has declared that, right to health and right to medical aid is a fundamental right? And it is a duty of the state to ensure right to health and right to medical aid, right? So the petitioner has also contended that, there is a violation of fundamental rights of rural and tribal population under Article 14 and 21 of the Constitution, right? So health services should be provided to, educate health services to be should be provided to the tribals, right? In the state of Madhya Pradesh, there should be proper manpower, infrastructure, medicines should be available, and that too without discrimination, right? So health facilities should be provided to the rural and tribal areas. Now, see, in this case, what happens? The High Court of Madhya Pradesh has noted that this petitioner has filed all the data that was published by the central government, right? And in this case, the High Court has asked the petitioner to file some extra data, to collect some extra data during the last 5 years, right? How many doctors have been recruited? How many have joined? How many have left the services? Right? How many doctors have undergone compulsory rural posting? Right? So all these needs to be examined in this writ petition. So let's see what happens in this writ petition. But at least somebody has raised the voice, regarding the rights of the tribals of Madhya Pradesh. So good move. Let's see what happens. Let's discuss this case, Biswas versus State of Chhattisgarh. Right, this is a case, this is also a writ petition of 2021. Now, see what happens. The petitioner, she's a nurse, and the petitioner had undergone some spinal cord surgery, right? And she claimed reimbursement of medical expenses of some amount amounting to rupees 99,743, right? Now, the reimbursement of medical expenses of this particular amount was rejected, right? Because she has not intimated surgery, and because she has not intimated surgery, that is why she is not entitled to reimbursement, right? So the return of the claim was justified that post facto sanction cannot be granted based on the Chhattisgarh Civil Services Medical Attendance Rules of 2013. Right, so the petitioner filed this and submitted that, the surgery was emergent, and after that surgery she was supposed to stay in the hospital for 7 days, right? So the rule of informing the competent authority could not be complied with, right? So this was challenged, the that the return of the medical bill, uh, as arbitrary and as a rule that was not mandatory to be complied with. Right. So the petitioner argued that the right to self-preservation is a part of the right to life that is guaranteed under Article 21 of the Constitution of India. Right. So, in this case, the petitioner also submitted that, her family members, they could have, they could not inform the authorities, right? And this cannot be the ground of, you know, refusing her claim of medical reimbursement. So, in this case, the High Court of Chhattisgarh, it referred to the rules of medical reimbursement and held that in cases of emergency, intimation to the concerned department is required within 48 hours of, treatment, commencement of treatment. In this case, such communication was not made, right? And whether the rules relating to post facto sanction can be covered or not. So the court also, referred to one of the landmark judgments of the Supreme Court, Consumer Education and Research Center and others versus Union of India. Right. So in this case, it was held that right to health and medicine is to protect health, right? And if a person is in service or post retirement, even then it is a fundamental right under the Constitution of India under Article 21. Right. So in this case, the court observed that, petitioner has the right to take steps in self preservation of her own life because it is a facet of the right to health. Right. So the court in this case held that, non-intimation of commencement of treatment within 48 hours would not, deprive her from recovering medical reimbursement under the rules of 2013, Chhattisgarh rules, medical rules of 2013. Right. Because right to self-preservation is a facet of right to health, and that cannot be declined to a medical patient. Right. So these were some of the judicial interventions by the Supreme Court, and recently so many writ petitions that have been filed in the various High Court of Madhya Pradesh, Chhattisgarh, and other high courts. So we have completely and fully covered the landmark judgments and the judicial interpretation on right to health. So thank you and keep watching.